that tonight we have a very, very special guest that Isabel and I, well, in actual fact, it was Iz. Because Iz suddenly said to me, when we were up in Canberra, she said, Virg, we've got to go and find Jacquie Dundee. And I went, what? And off the little purple umbrella went in the crowd. And I'm thinking, I can see the purple umbrella, I'll chase after the purple umbrella. That was it. So we actually went to the stage. We had a big burly security guard there, and she said, can you see Jacquie Dundee? And I'm going, no, I can't see Jacquie Dundee. She said, do you think we'll be able to get past the guard? I said, let's go around the back of the stage. So off we went round the back of the stage, came on the other side, there was this big burly female guard. And we said, do you know Jacquie Dundee? She said, oh no, I think she's gone. And then it goes, well, all I saw was this bit. And I said, well, I saw all this bit. So she said, that woman's got a similar hat on. And I said, no, I don't think that's Jacquie. Well, you're not Jacquie Dundee. No. So we're walking away feeling very, very disappointed. She's saying, Virg, I've been told we have to find Jacquie Dundee. And there was Jacquie sitting on one of the cement benches or barrages, and I went, there's Jacquie Dundee. And she said, you're joking. And I went, no. And we went, Jacquie Dundee. She went, yes. And we went, great. So this goes.
Oh, it's embarrassing.
And we went up to Jacquie Dundee and she said, I was told I had to find you. And Jacquie went, wow, okay. And she said, would you come and speak in Maitland's Bay? She said, where's that? Exactly. So, with great, great pleasure, Jacquie had said that she would come and talk to us. And basically, what she's going to talk about is the validity of the Act, the validity of the Constitution, law, and what it means. So, if you want to add anything more to that, no. So for us tonight, this lady has been doing research for many, many years. And she's going to talk about some of the things that are important for us to understand as people when it comes to dealing with the law. And what it means for us with the work that she's doing that will give us a winning streak, if I can put it that way. Okay, so we ask that we let her have a talk, let her do her speech or her presentation. We ask no questions, please, until the end, because of the fact she's got a lot to tell us. At the end of it, we're going to close at 8:30. We've got some sandwiches, etc., that we can all have a little bite to eat, and then you can come up and ask Jacquie some questions. We will be watching, only because if someone's spending too much time with her and there's somebody in there, got 3 or 4 people behind us that want to talk to her, we're going to say, we're now going to let the next person in. And I know that sounds absolutely rather teacher type mode and controlling, but at the same token, she's only here for a short period of time, and we really want every one of you to benefit from either speaking to her or asking questions that you have or concerns. Okay? So, with no further ado, Jacquie, the audience is yours.
Thank you very much, ladies. It's an absolute honour to be asked to come and speak here. So firstly, I must make the disclaimer here that I have got absolutely no legal qualifications whatsoever. But what I'm going to present to you tonight, you can all look up yourself. But I've even, I've got this on my computer, so I can email this out to everyone so you can look up all the pertinent sections of the Constitution and the case law. So we have constructed a very small group, there's only 4 of us in it. But we have all been researching the Constitution and case law. So we're using the highest law in the land, which is the Constitution. We are also using all of the case law from the highest court in the land. And that law is binding on all the courts in every state and territory. Now, I've got respect for anybody who is trying to fight this, and there are many of us that have been doing this for decades. I have the utmost respect for One Glue, Brian Shaw, there are many, many, Dick Yardley, etc. But I look at it and I think there's been no remedy. So the way we've structured what we are doing is we're not going after the man. There's no point in going after the man, they just put another puppet in their place. We need to invalidate and remove where they're getting their authority from. So that's what I'm sort of going to run over. You've also got to ask yourself, if somebody says they know the Constitution, you need to say to them, well, do you know case law? If they do not know case law, all they are doing is doing a recitement of the Constitution and using their opinion. Now, we're not doing that. We use the Constitution with the opinions of the highest judicial intellect in this country, from high court case law that's been determined over decades. In fact, some of it goes all the way back into the early 1900s. So the strategy that we use in our cases, and we have got, I think we've got 12 cases all up, which I will run over. But the strategy we use for our cases is to create arguments using what we call the Socratic Method. So we use the Constitution, we use High Court case law precedents, the Rule of Law, Chapter 3 of the Constitution, and the Judiciary Act. Now, all the questions of law we create are those that we already know the answers to. So, and they've all been answered in the determinations of High Court case law, not just in one case, but on numerous cases. And we use cases where there's been a unanimous decision by all 5 to 7 of the justices and the Chief Justice. So, the Constitution was removed from the curriculum in the 70s, and they did this on purpose. This has been, it's been an agenda that's been going on for, decades. It's been going on for a lot longer than that, the control. But it was removed for a reason. They had hoped that it would be forgotten and the people would have no understanding of what their rights are. And the Constitution provides for us protections and guarantees that cannot be removed. Now, I'll just do a brief history. So I just want to sort out the hierarchy of law. So the mere act of federation in Australia brought about our freedom of movement. So that was to cross all state boundaries and to access the seat of government. It's the same as the United States. Our Constitution is very similar to the United States. We just don't have a Bill of Rights, but our Constitution is actually better than the United States. So at the Act of Federation, the first practical operation of the Constitution came into play. The states all relinquished their power and we became one under the Commonwealth, united, all equal in the eyes of the law. Now, what I'll read you now is the overview, which is from the Constitution. The Australian Constitution has properly been described as the birth certificate of a nation. It also provides the basic rules for the government of Australia. Indeed, the Constitution is the fundamental law of Australia, binding everybody, including the Commonwealth Parliament and the Parliament of each state. Accordingly, even an act passed by Parliament is invalid if it is contrary to the Constitution. Clause 5 is operation of the Constitution and laws. This Act and all laws made by the Parliament of the Commonwealth under the Constitution shall be binding on the courts, judges and people of every state and every part of the Commonwealth, notwithstanding anything in the laws of any state. Now, Section 106 is the saving of constitutions. So the Constitution of each state of the Commonwealth shall subject to his Constitution. So they're the important words in that. So the states could hold on to their constitutions and their laws and their acts, providing they were consistent with the Constitution. If they were repugnant to it, invalid. So I've got here supporting High Court case law for that. So as I said, this is good that if I can email it out, I'll ask Isabel and Virginia if they can email it out to people if you want copies of this. So you can see the High Court determinations supporting this. So the first one is the Attorney General of Queensland versus the Commonwealth. It is 1915 High Court of Australia. Justice Isaacs stated, in the Constitution itself we find Section 106 declaring that the state constitution is to be subject to this Constitution. That is, state powers are to give way to the requirements of the federal Constitution. If they are repugnant to the Constitution, then they pro tanto, they cease to exist. We have then got, I'm only going to read you very small sections, otherwise I'll be here all night because these paragraphs are long. We've also got Cable versus the Director of Public Prosecutions for New South Wales. It's short to Cable versus DPP. It is a 1996 High Court of Australia case. Justice Gordon in paragraph 11. That follows from covering clause 5, which provides the Constitution is binding on the courts, judges and the people of every state and of every part of the Commonwealth, notwithstanding anything in the laws of any state. And from section 106, by which the Constitution of each state is made subject to the Australian Constitution. Now, under section 51 of the Constitution, this is where there are the powers of Parliament. So section 51 is the legislative powers of the Parliament. Now, under 51, it goes all the way through to 5139. Most of the topics within section 51 are what they call concurrent powers. So both the Commonwealth, so the federal government and the state government can write laws on the same subject matter. But this is also when I'll bring that section 109 comes into play here. But regardless, neither federal nor state laws can be inconsistent with the Constitution. So we have got the Parliament shall, subject to the Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to, and then it starts to list everything under section 51. Under section 51.9 we have quarantine. Now quarantine is actually what they have used. We have been subject to the powers of quarantine for, well, it's coming up to 2 years. So the powers of quarantine have been used capriciously, arbitrarily and absolutely disproportionately. Absolutely unlawful. Everything they've done is unlawful. So section 51, as I said, it confers concurrent powers to make laws with regards to quarantine. Should there be an inconsistency between the Commonwealth and State Acts, then the former shall prevail to the extent of the inconsistency and by operation of section 109, which I'll read later. So we've got in Chief Justice Latham in McCarter versus Brodie. So he is cited in a recent case, which was Gurner versus the state of Victoria. But in case of conflict giving to valid Commonwealth legislation, the supremacy expressly declared by the Constitution, measuring that supremacy according to the very words of section 109. Now, I'm going to give you a couple of examples of cases, High Court cases here tonight. There are hundreds that back all of this. The foremost question in one of the cases that we've brought to the court is whether the practical operation of the Public Health and Wellbeing Act of Victoria, this is 2008, but it is still applicable to the Public Health Act of New South Wales. I think yours is 2010. So we are questioning whether there has been an improper exercise of the state's quarantine powers. And all the case law and all our research, we know damn well it has been an absolute improper exercise. So the powers of the state to prohibit or restrict a person's liberty of free movement can only be exercised on 3 grounds. So that is, if you have committed a crime, if you are suffering a mental illness and you may cause harm to yourself or others. And the third is quarantine. But that quarantine is only for you if you are ill, diseased, or labouring under an infectious disease. Quarantine cannot be used arbitrarily on a healthy population. And it's exactly what they've done. So we have got... So in all 3 of these examples, they cannot arbitrarily or disproportionately exercise quarantine. Everything must be based on facts of evidence. So they can't just randomly do this. They've got to justify the removal of a person's liberty. So we've got a lot of work to do, and it's important that people sort of... Everyone's confused with what's going on because it's just been fear-mongering. That's all it has been. And the 3 greatest weapons against mankind are fear, doubt and confusion. And my God, how confusing is it? They totally contradict themselves and change everything. Everything is upside down. Daily. And the confusion makes people... People that don't know any better, they question it, they know something's not right, but they can't put their finger on it. So that's that's what I'm going to try to do tonight, is to show you exactly how they have perpetuated this situation. So we've got the supporting High Court case law for quarantine, which is section 51.9, which is Palmer versus Western Australia. Sham case, by the way, but I'll go into that. So Edelman, Justice Edelman in the Sydney debates is quoting Dr. Coburn. Hence, while diseased persons or diseased animals may be prevented from entering the state, any general law of exclusion measured by months, that's the most they can do for diseased or ill animals or people, should not be operating in such a way as to become a barrier to commerce or travel. Because that would be a regulation of commerce forbidden under the Constitution. So it's more than any quarantine regulation has the power to do, and it transcends the legitimate powers of the state. Everything they have done is outside of their legislative authority. They've got no power to do this. It is absolutely ultra vires. They've gone beyond the power. We've then got 5123A. So this is where it comes into, you cannot mandate medical services. So this is where the, so it's not to authorise civil conscription, and it's very important. There's a ton of case law on this. So you'll find that section 5123A, this is where it's noted all about allowances, benefits, pensions, etc. But under medical and dental services, following straight after that to emphasise within the brackets so as not to authorise any form of civil conscription. Now there's lots of case law on that. We have got Wong versus Commonwealth, a 2009 High Court case. Nearly everything I quote tonight is going to be High Court of Australia. It's the highest court in this land, and any other court's decisions do not cover the Commonwealth. They're only applicable to the state. So we've got Chief Justice French and Justice Gunnell. Any form of civil conscription is a compulsion to serve. As I said, I'm going to cut these down, just take the pertinent parts. Justice Gibbs in Wong versus Commonwealth. Civil conscription as involving some form of compulsion or coercion in a legal or practical sense. So you've got to think, everything we do in law, for example, any contract you sign whatsoever, whether it's disclosures or what have you, if any contract is signed under fear, duress or coercion, it's invalid. It's invalid. That is a general rule. It's not worth the paper it's written on. Exactly. Yeah, I'll go into that. So, as we know, people have been forced into these, well, they're actually they even class it on Moderna, AstraZeneca and Pfizer sites. It's a gene therapy injection. It's not a vaccine. Yeah, I won't go into the subject matter of that, but I think we all here know exactly what it is. It's a gene mutation injection with spike proteins that cannot be controlled. We've then got Justice Kirby. This is Wong versus Commonwealth as well. To require a person to do something which he may lawfully decline to do, but only at the sacrifice of the whole or a substantial part of the means of his livelihood would, I think, be to subject him to a practical compulsion amounting to conscription. If Parliament cannot lawfully do this directly by legal means, it cannot lawfully do it indirectly by creating a situation as distinct from merely taking advantage of one, in which the individual is left no real choice but compliance. And that's what we had with I don't know what percentage of the population. The majority did not want these vaccines. They were left with no option because they were threatened with loss of their livelihood. Why do you think Scott Morrison made the statement, no, we cannot mandate these vaccines, we don't have the authority? It's because of section 5123A. And the state ministers did the same thing. We have a government that is acting under a pseudo-jurisdiction at the moment. They are acting as though we are a republic. They are disregarding every law in this land. Constitution, their federal acts, their dodgy state acts, they're not adhering to anything. Justice Kirby, I will go on. So the words in brackets, so as not to authorise civil conscription, is special, limited and necessarily restricted to those involved in the provision of medical and dental services. They also include of necessity the patients who are the recipients of the provision of such services. There's been a lot of misconception with the doctor-patient relationship and medical and dental services so as not to authorise civil conscription. There were people that were falsely claiming that this only applied to doctors. No, it doesn't. And High Court's case law clearly shows. I mean, if you don't have a patient, there's no contract. Of course it includes the patients. And we've got all the case law to show that. So, Justice Kirby, I've got 107, 124, 125, 126, 127 and 128. He goes on for pages and pages, but it's gold. But once again, if Virginia can email all of this to you, you can read over it all, and because it takes a while to absorb it all in. So, under paragraph 126, still Justice Kirby, in this sense, the prohibition is expressed for purposes of protection, including a protection extending to the patient. It is designed to ensure the continuance in Australia of the individual provision of such services as against their provision, say entirely by a government-employed or government-controlled healthcare profession. It's amazing when you start to go into these cases, and even some of the early ones, they're saying exactly what's occurring now. Paragraph 127, the prohibition on any form of civil conscription is designed to protect patients, once again, from having a supply of medical and dental services otherwise than by private contract forced upon them without their consent. I love paragraph 128. A rare constitutional guarantee of it because of its character as a guarantee or protection, both for the healthcare professionals identified and for the patients. Exclusion of any form of civil conscription must be seen as one of the rare instances of an individual guarantee and protection spelled out in the Australian Constitution. He is very highly regarded Justice Kirby. He comes out with a lot of wisdom in a lot of cases. We've then got Justice Hayden. The proposed, so this is from, he's quoting, okay, so he's quoting Dr. Everett. So this is from the from the Attorney General of Victoria versus the Commonwealth, this case. This is a 1945 High Court case. So Justice Hayden is quoting Dr. Everett, and he claims, this is what his statement, so the proposed section 5123A, so I'll go into that in a minute. So this case actually brought about the amendment in the Constitution, and that's what the A stands for. At 5123A, it stands for amendment, and that amendment was put in because of this case. So the proposed section 5123A would not affect the state laws regulating the right to practice medicine or dentistry, and would not affect the right of a doctor or a dentist as an individual to practice his profession. No authority will be vested in the Commonwealth to control health generally, the general practice of medicine or dentistry. The BMA case, this is known as for short, it's the British Medical Association versus the Commonwealth. It's a 1949 High Court struck case. Justice William, now with a lot of these old cases, they're not in paragraphs. They just used to write, so it's all with page numbers. This is page 286, civil conscription. So that, I can't remember all of these High Court cases off the top of my head, but I've got to make sure I am correct. So that the punctuation tends to confine the expression to the words medical and dental services, because it falls straight after that. So, and we've got all sorts of other cases about that. The Committee of Direction of Fruit Marketing versus Commonwealth, that's another case that outlines this. But he's saying that in his opinion, it is the true intent of the paragraph. So as not to authorise any form of civil conscription has been purposely put after health and dental services. So they've really put an emphasis on those two by putting the bracketed words after. So we have then got, this is still the BMA case, conscription as a word of general application would seem to signify compulsory as opposed to a voluntary service. So they're making it very clear. A lot of people always, see once again it's another misconception with conscription, because everyone puts conscription with army. This is just generally conscripting people to do things against their will as opposed to voluntary. Now we've got at page 287, the prohibition upon the exercise of the legislative powers of the Commonwealth under section 5123A of the same character as the prohibition contained in section 92 and 116 of the Constitution. It invalidates all legislation to which it applies. So here they're telling us, if any legislation comes out that goes against our guarantees, so section 5123A, that is one of the guarantees and protections provided in the Constitution, as is section 92 regarding freedom of movement, and also the all taxes have got to be free. So that's a case we're doing actually, because it's never been determined in the High Court, it's always been put to the side. But that's a case we're working on at the moment. But for the time being, section 92, freedom of movement. Conscription as a word of general I'll repeat that, as a word of general application seems to signify compulsory as opposed to voluntary service. This is another justice saying the same thing. So the expression invalidates all legislation which compels medical practitioners or dentists to provide any form of medical or dental service. Now what they're doing is they're refusing to allow people in hospitals unless they're double vaccinated. I'll go into the civil conscription things. This is brilliant. This is Justice Webner. It falls on page 292 to 293. And this is from the BMA case, British Medical Association versus the Commonwealth. So as to civil conscription, that legislation for the purpose of benefits or services of the kind referred to could not authorise compulsory service of any kind, at least in the provision of medical or dental services, to any extent or of any nature, whether legal by the imposition of penalties or practical by any other means, direct or indirect, once again, could not be authorised. To require a person to do something which he may lawfully decline to do, but only at the sacrifice of the whole or a substantial part of the means of his livelihood would, I think, be to subject him to practical compulsion, amounting to conscription, in the case of services required by the Parliament to be rendered to the people. If Parliament cannot lawfully do this directly by legal means, it cannot do it lawfully. Do it indirectly by creating a situation, as distinct from merely taking advantage of one, in which the individual is left with no real choice but compliance. That's exactly what's happened, and this is from 1949. It's exactly what they have done. They have given people no choice but to comply because their livelihoods have been threatened. The Australian government is trying to conceal information about from us, the Australian people. So Scott Morrison is trying to pass a bill now to conceal what has transpired in this dodgy National Cabinet. Then the National Cabinet, that was all about the Commonwealth and the states got together to see how they could deceive the people, how they could manipulate us into doing something we didn't want to do, that they were not authorised to do. And if people knew their rights, such as the employers and the companies and the corporations who were threatened with hundreds and thousands of dollars of fines if they did not comply to enforce vaccination upon their employees, they would have also said, hold on a minute, that's unconstitutional. You can't make me do that. But they didn't know any better, so they did it. And then you've got the employees left with no option. Sorry, mate, you've lost your job unless you can show us this. It's a crime. So basically, It was standard tactics of fear and duress. So once again, if any of those employers, companies, etc. signed anything, those contracts are null and void. They were signed under duress, under threat of penalty in the hundreds of thousands of dollars. It's a shame nobody questioned it. This is what blows me out. I just think, for God's sake, we're a population of 25.5 million people. Why did somebody not question this? When the government is clearly making public across the media and the news, no, we can't mandate them. Both the federal and the states made that clear. So how can you fine us then if you can't do this? Everything is so ridiculous and so turned upside down. I find it astounding. So the Commonwealth government did indirectly what it can't do directly. We've got lots of we've got a case that we're doing at the moment. See, the Commonwealth has provided the funding for the vaccinations. That's what they've done. That's all they're allowed to do. They are only allowed to provide the funding for medical services. And the states provided the civil conscription. So between the two of them, they've colluded. So the civil conscription that is forbidden under section 5123A of the Constitution, once again, they've done indirectly what they're not allowed to do directly, and they damn well know it. And that's why they said, we've got no authority. They're still scared of the Constitution, they know it stands. So the purchase of the vaccinations, as I say with any medication, this is the other thing we're not quite understanding. It is ordinarily bought by the pharmacy. So it's the pharmacy that goes to the big pharmaceutical companies and purchases the medication. It's not the Commonwealth government. The Commonwealth government then, through any benefits, pensions, etc., where there has been funds that need to be made up to make up the cost of the medication, that's where the Commonwealth comes in and says, these people are on pensions, they only pay half price, so we're going to come in and reimburse the pharmacies. That's not what they've done. They've just gone out and bought trillions of dollars worth of it's not a vaccine, a gene therapy injection that can only be used, it's only got approval to be used in states of emergency. So government, how did you know that the state of emergency was going to be going for this long? That you went out and bought trillions of dollars worth of vaccines. And the vaccines aren't free. Those gene therapy, they're not free. That's our taxpayers' dollars. They're paying for that with our money from the Consolidated Revenue Fund. It's insanity what's going on. Everything is so wrong. We are living in an upside-down world. I mean, there's a spiritual war, as I say, but this is evil, and they've flipped everything upside down. The Commonwealth also created the AIR Act, which is the Australian Immunisation Register. That Act civilly conscripts doctors to provide the vaccine status of patients, backed by penalty if they don't do it. So I've got all those sections as well in here in the paperwork that can get sent out to you. So they not only civilly conscripted Australians, forced them under threat of loss of work, they've also civilly conscripted the doctors. This whole thing is absolutely criminal. Now, we cannot find, and we are still questioning, the legislative source of authority in the Constitution that actually allows the Commonwealth to directly purchase the vaccines through the Consolidated Revenue Fund. We're still questioning it. We've also got the Health Identifiers Act 2010, and pursuant to Section 38, it is also invalid because it allows the collection, use or disclosure of any information between Australia and places outside of Australia, such as New York, where World Health Organisation is based. I'll go into that later. So, the supporting High Court case law. The Commonwealth has no power to make any laws regarding health other than quarantine where concurrent powers. But in general, for any sort of social benefits, health, they cannot make any laws. They're banned from it. They've got no authority. All they can do is provide the funding for the services. So we've got Chief Justice Latham and Justices Rich, Stark, Dixon, McTurnan and Williams. And this comes under, they are talking in the pharmaceutical benefits case of 1945. They decided that the existence of the Commonwealth and its status as a national government did not provide the Parliament with power to enact the social welfare legislation. Now, as I said, I'm only quoting from you a few cases. I'm only going to give you a handful of cases tonight. There are hundreds that back all of this up, but it's important that people can go and actually research this yourself, because this is not my opinion. This is law, and it's been blatantly disregarded. So the Attorney General of Victoria versus the Commonwealth 1945, that is the case that determined the Commonwealth's only legislative authority, their only power in regards to medical and dental services, benefits, endowments, pensions, is to provide the funding for those services. They do not have any legislative power or authority under the Constitution to make laws regarding medical services. Now, the states, however, they can make laws regarding health services. So, Malcolm Roberts, you've twisted it a lot, mate, because the state governments can only make laws regarding health regulating the providers of the services. They can't make any laws regulating us. We're the people. They can't tell us we've got to go to the doctor, we've got to get this done, we've got to get that done. No. But they can make regulatory laws for the providers of the health services. That's it. They know they're in the wrong. So I used to say to protests, I mean, want everyone chanting in the street, the Constitution is supreme. That's making them shake in their boots, and we're coming after them. Section 81 is where you'll find the Consolidated Revenue Fund, where all revenues or monies raised or received by the Executive Government of the Commonwealth shall form one Consolidated Revenue Fund to be appropriated for the purposes of the Commonwealth in the manner and subject to the charges and liabilities imposed by this Constitution. Now, the High Court, actually I might do that one later. I want to go back to that one. I want to get through the sections of the Constitution for you first. Oh no, I'll do it. The High Court. So this is where we are taking our cases. There is no point in going to any other court in this land. Now, my opinion's coming in. Every other court under the High Court is corrupt. There's no doubt about it. All the lawyers, all the solicitors, all the QCs, in my opinion, are corrupt. They have all signed agreements with the states when they get their bar, their degree. They've also signed things with the courts. They're not going to go against them. It's a conflict of interest against the people. They will never go in against and do a true case. So this is one of the notices that we sent off to the High Court right in the beginning. So the justices of the High Court, I came back into this jurisdiction because I started to say some of the people here tonight. I started to go down the path of Magna Carta. I did my lawful rebellion under Article 61. I went and did the quantum and the syntax. You know, I paid for the labelling of this vessel. I've done all that stuff. I've got my C-pass, I've got my life claim. I'm common law court sheriff. But the thing is, none of it is working. None of it's working. We've got to get back in and we've got to use their own system against them. So as I said, we're going in. And when we go into the High Court, we use the Socratic Method. So, Your Honours, we ask them the questions. You yourselves, Your Honours, in your wisdom, make these decisions. We know the answers to the questions we ask them. Because they've been determined not just in one or two cases, numerous. In the tens, some in the hundreds. It's been determined. And as I said, the cases that we choose, it's been unanimous. It's not like two justices, you know, were for it and then the other three were against it, or vice versa. This is unanimous. Full benches, 5 and 7, all agreeing. That's the High Court's case law precedents we use when we structure our cases. So the justices of the High Court, and all the court actually, are under oath to uphold and enforce the protections and guarantees the Constitution offers the Australian people. Now, the High Court is the only court in this land that has not been created by an Act of Parliament. All the courts below the High Court have been created by an Act of Parliament. So the High Court owes its very existence to the Constitution. The court is the mere mechanism by which Australian people access their constitutional protections, and its defining purpose is to maintain the Constitution and enforce without fear or favour the restraints it places upon government. Now, the implied rule of law under Chapter 3 of the Commonwealth Constitution is efficacy, and it includes access to the court, the right to natural justice, both a fair and unbiased hearing, and equality before the law and the court. So, what's going on here, as I said, the state and the Commonwealth governments are ultra various. They're not adhering to anything, so it appears that the states have reverted back to pre-federation. And they are all demonstrating an utter disdain and contempt for the Constitution. The states, aided and abetted by the Commonwealth, by exercising powers they simply do not have, such as lockdowns and border closures. These have got no basis in constitutional law. Furthermore, it appears, this is what I said earlier, that the states and the Commonwealth have colluded to defeat the Constitution and the restraints it places upon them, united by the use of these measures which exert great economic pressure to force vaccination upon the Australian public. The use of the police force, my God, in Victoria, God, we were hammered. I had lucky Virginians working my leg. I've got nerve damage still. I still can't move my foot. It's been cooked for 15 months. Yeah, they used a lot of force. So it's been violent, it's been brutal against the public. Anybody who dares voice their disapproval, and it's all designed to silence those voices who are engaging in the constitutionally protected activity of protest, which comes under the implied freedom of political communication, which you'll find in the section 724 and 128 of the Constitution. It is an implied freedom of political communication because under those sections, that is where it is all about elections and we the electors. So this is something else that's turned upside down. The government doesn't tell us what to do. They sit on the bottom. The hierarchy is other than God or the higher energies above. It goes, we the people. We are the power. The Constitution sits below us to protect us. That's what it's there for. The government, they're a public service. We elect them in to adhere to our will. All of a sudden that's flipped totally upside down. We've got to fix this country. We've got to do it fast. There's a lot more going on under the scene, behind the scenes, and I think most of us will be aware of that. I'm not going into that. This is a distraction. And whenever, you see the media focusing on something and plastering across the TV, it is a distraction. There is stuff going on. We're in trouble. We're in major trouble. Okay, sham cases since COVID-19. Now, the most publicised of these was Hyde Palmer versus WA, and the second was Gurner versus the state of Victoria. Both of them were in 2020. Now, the two cases that were brought before the High Court, Palmer versus Western Australia and Gurner, they had no basis whatsoever in constitutional law. They were frivolous and ill-conceived. So this is what we wrote into the High Courts, just saying, why the hell did you hear these cases? I'll tell you why. Because they were billionaires and millionaires. That's why they heard it. Anyhow, so, respectively, so they all conceived, failing to allow a constitutional guarantee such as Section 92 or the implied freedom of political communications contained in Section 724 and 128 to ever be correctly applied to the state acts, as they knew they would not withstand these protections and be found to be invalid. Now, in Palmer, by arguing under the statute against the directions, okay, let me try to keep myself honest, that's all really. Okay. So, the way this works, okay, so this is what's going on with sham cases. All of these lawyers, Clive Palmer's QC, Mr. Dunning, he knew damn well what he was doing. We researched him. We found another case where he did exactly the same thing. So it's not just Palmer versus WA, he did it in Liberty Works versus the Commonwealth as well. So the restraint of the Constitution, so you've got the Constitution, okay, and then you've got the Acts. Now, the Constitution has the restraint upon the Act. Now, if they're not challenging the Act, and they are only challenging the directions of the chose, So this is what they did. In his originating motion, Mr Dunning put in for Palmer that he was going to be challenging the validity of the Emergency Management Act 2005 and or the directions of the Western Australia Chief Health Officer. When he got into the court, he didn't do that at all. All he did was challenge the directions. You can read this in a transcript. You can read it in the transcript. Chief Justice Keefe asked him 3 times. It's like she was in disbelief. And this is sort of brought me back into seeing that the High Court is doing the right thing. You've got to understand, they are only there to adjudicate. They can't add into the argument for either side. All they're there to do is adjudicate. And in all of these determinations of these sham cases, they're telling us exactly how to do it. So the restraint of the Constitution operates upon the Acts. So the Health Acts, okay? So if you are going into the High Court and you are raising a matter under the Constitution, you need to be challenging the validity of the Act, in part, in whole, or its practical operation. What are they doing? They are challenging the directions of the Chief Health Officer. Now, where's he get his power? He gets it from this Act. Now, they've clearly written in all of the determinations, the restraint of the Constitution operates upon the legislative power, the Act. It doesn't operate upon the actions of executive officers. If they're questioning the directions of the Chief Health Officer, they are automatically assuming that these acts are valid. If they're not questioning the Act, it's assumed it's valid. This is how they're doing this. It's crazy. So that was done deliberately by Mr Dunning. Deliberately. He's a QC, he knows constitutional law. So the way it goes is, that case failed in 2 elements of jurisdiction. I'll go into jurisdiction a bit later. Okay, so dodgy as, that was the main one. Palmer versus WA, Gurner versus the state of Victoria. Oh my God. Most of the High Court cases, okay, average about 300 or so paragraphs. Gurner versus the state of Victoria lasted, I think it was 36 paragraphs. They threw it out of the court. It was a joke. It was the most frivolous, ill-conceived case the High Court has ever seen. Guess what? The media picked up on it, didn't they? And this is what's going on. So, in Gurner, his legal representatives did a similar thing. They didn't question the validity of the Act. There's no constitutional matter there. They even came up with farcical arguments. It was ludicrous, asking the court to find an implied freedom of movement in the Constitution to deny the states any ability to regulate people's freedom of movement. Nothing made sense in the whole case. And as I said, they threw it out after 36 paragraphs. It was an absolute joke. The lawyers went further this time. They also showed a complete misappropriation of Section 92, trying to assert that the freedom of trade and commerce and intercourse also applies to intrastate, within a state. No, it doesn't. The whole thing was a joke. So once again, it demonstrated either their ignorance of constitutional law and settled High Court case law, or it was a deliberate attempt to deny the people their constitutional guarantees. So both Palmer and Gurner were united by the 2 attributes. Both were being very wealthy, a billionaire and a millionaire. And they had very highly accomplished, and they were represented, at their highly trained, expensive legal counsel. They knew damn well what they were doing. They threw these cases. So the public's confidence in the court, not so much the court, I think. What's going on with all of these cases is that the media is very quick. They're not picking up on anything genuine that we're doing. Nothing. They leave that well and truly alone. They don't want the people to know. But all of these cases, we're finding that we're having fun actually, some of the arguments we're having emailing, because we're in a lot of different courts at the moment, which I'll go into, but they're actually using these farcical cases as examples. So we're hammering them, which is great. We just laugh as soon as we say, kidding me, they're using that case as an example. So what happened in Palmer? Okay, with Palmer, when you go into the High Court and you are in there because you're raising a matter arising under the Constitution, for example, you must raise a constitutional question. If you do not raise a constitutional question, the judicial powers of the Commonwealth are not engaged. So there are three elements. Jurisdiction is a big, big thing. It's massive. You must, if you fail in one element of jurisdiction, the case must be thrown out. It's dismissed. They can't do it. So jurisdiction is, first jurisdiction is by the people, so you must have joinder with the applicant and the defendant. You must have joinder. The second part of jurisdiction is over the subject matter. So if you're raising constitutional matter, it's got to be involved in the Constitution. The third one is the court, is up to the court itself. So the court must examine itself once it's gone over the subject matter before they even accept the case and say, okay, do we have the jurisdiction to actually adjudicate on this matter so that the decision that we make is lawful? Because if they don't, it's unlawful. So what happened in Clive Palmer? They did not raise a constitutional question, so they did not engage the judicial powers of the Commonwealth. Therefore, failed. On jurisdiction 2, the subject matter, failed. It also failed in the first element, which is the joinder. Because if Mr. Dunning is going to be questioning the directions of the show, he should be the defendant in that matter, not the state of Western Australia. The state of Western Australia should have only been the defendant if he was challenging the act. If he was challenging the individual, they would be in there as the defendant, also upside down. So the judicial powers are not engaged in Clive Palmer. And Section 92, because they didn't raise a constitutional question challenging the validity of the Emergency Management Act Western Australia 2005. I'll repeat it. The restraint of the Constitution operates upon the legislative power and not the actions of executive officers. Being told over and over and over again in determinations, what are the lawyers doing? I love you, Tony, if ever you get to see this from AFL, but man, this is why I keep hammering you. You're doing the wrong thing. AFL did the same thing. Sorry, Tony. But I get it, you know, I keep hammering you. So, the High Court, what they should have done in the Palmer cases, they should have dismissed it and remitted it to a lower court. Because that's not for the jurisdiction of the High Court. That's for a lower court to deal with. So, and had no joiner because there was no constitutional matter raised. State WA was the wrong party. He should be shot, that man, I'll tell you. I don't even know who his chief office, the health officers are. I don't even know who politicians are, to be honest with you. I've got no idea who's where in what part of the country. I only some of the main ones. I don't know their names, so I'm naive with that. We also have the case of Cottrell versus Romanes. Avi Yemeni, Revenues. I mean, this is publicly, but I won't put it out there to the thousands. He's an absolute scumbag. He is ripping Australians off and he's ripping them off blind. We went over all of Avi Yemeni's cases where they are raising hundreds of thousands of dollars for all of these individual cases, making it as though this is for the Australian people. No, it's not, Avi. We went over all your cases. What you've done is you've cherry-picked individuals, got the Australian people who are struggling to make ends meet, put money into it, where these people could have had the same outcome by using another lawyer and paying $1,500 to $3,000. He's done it over and over and over again. Then we had Cottrell versus Romanes. Now, this is where I connected up with David Weisinger and Tony Pecora. So, the Cottrell versus Romanes, Kerry Cottrell was working for Avi, and she got charged under the directives for breaching because she had a protest sign on her. So as the case goes along, David and Tony get added in. So Madeline Smith, David put it out there to the lawyers. Someone said, listen, I'll put it on the lawyer network. Madeline Smith responded, Avi Yemeni's solicitor, said, we can help you, come and join this case. So I met up with the guys and they knew that what they had, because they were being done for incitement, it is a constitutional matter. It is the implied freedom of political communication, section 724(128). Both of them have enough nous to know, okay, that's a constitutional matter, so that needs to be us against the state of Victoria, heard in the High Court. The other person involved with this was Kathleen Foley. She's a barrister. They all colluded. They submitted the case into the Supreme Court and made the defendants Finn Romanis and Brett Sutton, the Chief Executive Officers. Now the thing with that case, even the VGSO, who were representing Romanis and Sutton, I got all the emails, as I said to Arby last time, hey mate, you want to be fully transparent? How about we release all the emails so people can actually see what went on in that? They even admitted, see, the prosecutor, the police actually said to Kerry Cottrell, sorry, we made a mistake actually, you were within your 5 kilometres. So there's no charges, everything's dropped. So Kerry had no standing in that matter. The only two that had standing were David and Tony, who were being threatened with incitement and facing up to the worst penalty, 10 years imprisonment. For Tony put a post up saying, hey everybody, how about we meet in the park, in between that 1 hour we can exercise and walk around with protest signs. So he's arrested. They hammered him and his family for months. They terrorised him. He lost his business over it. And David the same. So they were the only ones that had true standing. And as we're putting all our arguments in, the VGSO were agreeing with us and they said, look, you actually, Madeline Smith, Kathleen Foley, your client's got no standing. She shouldn't even be here. There's no case there. But they kept plugging along. So Justice Knowles in the Supreme Court did the wrong thing by dismissing David and Tony, but we hammered him. We sent him out I think it was a writ of certiorari. Regardless, they got no charges and Kerry Cottrell got hammered with heaps. But the point I want to make with this is how dodgy they are. Kathleen Foley is the barrister that was involved with a landmark precedent case, which was Dr. Brown versus the state of Tasmania. It was on exactly the same topic. It was the implied freedom of political communication. She knew how to win that case. She knew it should have gone into the High Court, and she knew that the defendant needed to be the state of Victoria. What did they do? They adjourned the case for 1 week. What did they do in that week? They studied the failed Clive Palmer case and replicated it. She knew how to win it. She'd already done it in a landmark case as a junior, but she was involved in it. She knew what to do. So what's occurred with all of these cases is the media have then picked up on it and plastered it all over the TVs saying, well, all of these directives and what's been put in place has been challenged in the courts and it's been found that none of this is unconstitutional. Now that's a blatant lie, because that's not what the case is determined at all. As we know, the media lie, but that's an example. Nothing could be further from the truth. We then started to send stuff off to the Governor-General. Look, I know all the arguments and things. There are so many silly arguments over the Constitution, if it was dissolved and it doesn't exist. It does exist, and it doesn't matter what has occurred. That Constitution is our protection. It provides us with guarantees, and it does still stand. High Court's still running. If the Constitution wasn't in place anymore, the High Court would have been dissolved. And as I said, they're doing the right thing. In all of their determinations, they are telling us exactly what to do and how to win this. But all of these lawyers and solicitors keep going, we're going to go to the Supreme Court or the Federal Court and let's take another health officer in. It's crazy. Anyhow, okay, so the Governor-General. Now, they, and all the state governments, as a result of occupied public office, anyone who's in public office has a duty of care to the public to cause us no harm in the performance of those duties. And secondly, there's been a massive breach of duty. The Governor-General and the governors are required by law, the Constitution, not to provide royal assent to any act of Parliament, whether state or federal, that seeks to force a preventative medical service such as vaccination because it is strictly prohibited under section 5123A. So how the hell was the Public Health and Wellbeing Act passed in 2008? Because that should have been invalidated because it's forcing vaccination upon your children. Crazy. So their purpose and their sole purpose under the Constitution, Governor Generals and Attorney Generals, is to preserve the is to provide royal assent only to acts that are constitutional. That is their duty. So we've got a claim of negligence against every one of these bastards in public office. And the claim is well and truly satisfied. So it's a claim of negligence. We were saying misfeasance at the beginning of this. It's turned into malfeasance and unconscionable conduct all in public office. They know of the adverse effects. They know what's going on and they're still causing us harm. So with the evidence is all around, it is satisfied. People have suffered harm as a result of the breach of duty. People lost their businesses, some have taken their lives. It's insanity of malfeasance and unconscionable conduct and neglect, negligence in their duty. We've got questions that we ask them. What authority do the Commonwealth or the states or territories have to force any medical service, such as vaccination, against any person absent their consent? None. They've got no authority. We've also got, we've got a question. Why the health ministers give effect to the recommendations of who? It's a foreign entity. We want to know if the Governor General's received any recommendations from the World Health Organisation to vaccinate in regards to COVID-19. We've posed all these questions. What authority did the Commonwealth have to write into legislation to allow a health recommendation by a foreign entity such as who? Such as vaccination in relation to COVID, to make it enforceable by law and punishable by criminal sanction, knowing full well that section 5123A strictly prohibits any form of civil conscription, forced, legal or practical compulsion to receive any medical service. There's no authority to do any of this. Everybody has been frightened into this. So the Governor Generals and state governors cannot claim ignorance of the Constitution or constitutional law, especially the Governor Generals, because being the Queen's representative, it is their duty to give royal assent to acts of Parliament upon compliance with the Constitution. They're not meant to give it the seal otherwise, the royal assent. So then we've got the doctors. I still just don't understand why people just didn't stand up and say, no, I'm not recommending that to my patient. There's no long-term data on the safety and efficacy. How can I recommend that to my patient? I've got to disclose all of this information to my patient. You know, with any medication that I give, there's got to be full disclosure about the possible side effects, possible death, etc. There's none. There's no information. So doctors have gone against their Hippocratic oath. They can all be sued under the law of torts. It's insanity. And I know there are a lot of doctors and nurses that stepped out of this right at the beginning, but there were others that helped facilitate this by remaining silent and working in those hospitals for 12 to 15 months. When did they come out? When it was them. We've all got to stand together united. This is not about any self-serving agenda. We've got to unite as one and stop this. And they could have stopped it. They could have blown the whistle on all of this. Now the Commonwealth is also, doctors, once again, they've been civilly conscripted. So the penalty of fines, if they don't provide, this is another side of things, our private, confidential medical records to the government. Really? So that's the AIR Act. The Commonwealth is strictly prohibited to collect such information absent consent, our consent. And therefore it contravenes section 5123A as well. And census and statistics consist of numbers. There's no requirement for any patient details. So this is all about the digital identity. That's how they're rolling it out. Because that was their excuse. We need to know, how many people have had the vaccine. They don't, you could have been number 225, you could have been 1026. We all could have just been numbers, had numbers representing us. They didn't need our private information, our details. The AIR, the Australian Immunisation Register, provides coercive force backed by penalty to provide this information, our private medical information, absent our consent. To be used for the purpose of discrimination. Because this is the other thing, this is also, it's the creation of two classes of citizen now. You've got vaccinated and unvaccinated, whose rights are, they're different and lesser as recognised by law. The Constitution provides for no such discrimination or two classes of citizen. We are all equal in the eyes of the law as we are in the eyes of God. This is ridiculous. So I'll reiterate. The Commonwealth has got no power whatsoever to make any laws regarding health other than the quarantine powers. So they made the Biosecurity Act, that's a federal act. But regarding our health, not at all. And the states can only make laws to regulate the providers of the services. They can't make laws making us do anything. But they have, and they did, by keeping everybody in a state of fear, doubt and confusion. That's how they've done it. So you've got, I won't read you out the immunisation register, but you can see within that that's actually written in there, I think section 10A, where the provider must report within the period prescribed by the rules. And then you've got here the penalty, 30 penalty units, etc. It's crazy. So the other very, very important thing in law is the doctor-patient relationship. Now this has been established well before the Constitution. It was established over hundreds of years. So the privity rule applies to the Commonwealth and the states, and they are foreclosed for any rights or obligations under it. This government, it just has continued to do what it is forbidden to do under the supreme law of this land. Civilly conscripting the doctors to release their patients' confidential records. The doctor-patient relationship consists of what's called the head of powers postulate, and it consists of the doctor and the patient only. No third party, such as government or an employer, can intervene. There is so much case law on this, it's crazy. So the main ones, Brent versus Williams, 1996, in the absence of special contract between a doctor and patient. So a special contract would be a written contract. But it's stated, it is a contract between doctor and patient. Usually it's a verbal one. You go in, you speak with your doctor, oh yeah, okay, I'll do that. They give you all the information and it's a verbal contract. Regardless, it's contracting law. Then you've got Wong versus Commonwealth. This really is gold. If you want to go in and start studying case law, this is gold. Wong versus Commonwealth has got hundreds of paragraphs. Chief Justice Kirby again. Normally in our society, the provision of medical and dental services occurs pursuant to a private contract entered into between the healthcare provider and the patient. The purpose of incorporating a prohibition on civil conscription in the provision of such services is thus to preserve such a contractual relationship between the provider and the doctor and the patient. Paragraph 127, however, the prohibition on any form of civil conscription is designed to protect patients from having supplied medical and dental services otherwise than by private contract forced upon them without their consent. I've already done 128, that was the red constitutional guarantee, I love it. He states clearly that any form of civil conscription, the exclusion of any form of civil conscription, so as not to authorise civil conscription, must be seen as one of the rare instances of an individual guarantee and protection spelled out in the Australian Constitution, and the fact that the Constitution has taken the trouble to afford such a guarantee. Justice Hayden, an extremely important consideration which cannot be disregarded is the confidential relationship of the doctor and patient. It is a relationship akin to that of a solicitor and client, and priest and penitent. To disregard this relationship compels a doctor to abandon his normal duties and obligations to the patient. That's where their first obligation is to care for the patients. And they haven't done it. Okay, I'm going to, now Section 92. The true meaning of Section 92 has actually never been determined, but we're doing it. So the High Court's got a nice surprise. So I'll give you a clue as to what we're doing. It's in the first line of Section 92. On the imposition of uniform duties being taxes, of customs, trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. Commonwealth and state governments have been charging tax across borders. Can't do it. They've been doing it for over 100 years. A lot of money needs to be refunded. So the main case that sticks out is the supporting High Court case law for Section 92 is Gratwick versus Johnson. And this one really is very pertinent. Dulcie Johnson was trying to cross the borders in times of war. So she wanted to go visit her fiancé interstate. She's arrived at the boundary and she's stopped by Officer Officer Gratwick. And he said, I'm sorry, you can't cross the border, show us your papers. You're not getting across this boundary. Borders, forget borders. There's no internal borders, it's boundaries and limits, it's a bad habit. Wouldn't let her cross. She took it to the High Court. So the determination there was, the government cannot, restrict or prohibit our movement. All they can do is regulate our movement. And this is what you'll find with nearly everything. Whether it's federal government or whether it's state government, they cannot restrict or prohibit us. We are the power. All they can do is regulate us. So in regards to Section 92, for example, travel and movement, speed limits are put in place. So they regulate what speed you can travel. That's an example. That's all they can do. They cannot stop you moving. I've actually got a brilliant case. This was something else that was brought to our attention. God, I haven't got it in here. It was in the most whimsical, farcical case there has been in High Court history. I don't think I've got it written here, but I remember it. This was one of the determinations in Gurner versus the state of Victoria. We don't know how or why. They're trying to tell us stuff. I'm telling you, these justices. Supreme Court case law in America, the Supreme Court is the highest court in America, okay? And quite often, we use within our High Court examples of Supreme Court case law from the USA, because they're also considered the highest intellectual judicial minds in the world. So in this case, he brought into the determination of the case, it was Crandall versus the state of Nevada. It is an 1867 case. We couldn't believe, we just, jeez! And it clearly states, you just got to, as I said, our constitution is nearly exactly the same as America, so I'll just insert Australia instead of American. Every Australian citizen can cross the soils of our land unhindered across every boundary and every limit to access the seat of government to assert our claim. And we can also do that for trade and commerce and everything else. And if we just want to go visit someone. It's an absolute, it's a crime what they've done. Oh, there it is. I'll find it 3 pages later. I'm not going to go through all of that because I've got so many paragraphs, but we've got all kinds of questions as well, which we are asking. So, with this is the Crandall versus State of Nevada. The court reasoned that the right to travel, it is a fundamental right. So, the people of Australia, as America, we constitute one nation. We are the Commonwealth. I'll tell you something else. The only reason, all we've got is the external borders, okay? It's only the coastline. The only reason we have what are state boundaries and limits is because that is the jurisdiction where each state can legislate to. It's not for us. It's for the state governments. They can legislate in this geographical area. It's not applicable to us. We are the Commonwealth and we can go where we bloody well want. So, and once again, they brought this up in this case as well. The state may not impose a tax on a person for the privilege of travelling from or for passing through each state or across the entire country. We've then got the questions, if there was no section 109 of the Constitution, would an act of the Commonwealth have supremacy over an act of the state? And the answer is yes. Because regardless if there is a federal act sitting in between a state act and the Constitution is the highest law of this land. So that's where Malcolm Roberts, I really was very upset with that man because he's got a huge following. And he did a speech, I can't remember now, was it 12 months ago or 9 months ago, where he starts off and he says, a lot of people aren't going to be very happy with what I'm going to say, but I assure you, it's absolutely true and correct. And then he just went through some basics, and then he mentioned section 109, so he said, a little bit of factual information, and then he said, but the states can mandate. And his reasoning was because there was no federal act in between. So Malcolm Roberts seems to be of the opinion that the lowest laws or acts in this land, being state, can somehow jump over the top of the Constitution and do what they want. No, they can't. A stream cannot rise above its source. And the source of law in this land is the Constitution. It's just crazy what's going on. So I think a lot of people, he's Queensland, isn't he? Malcolm Roberts.
Yeah.
A lot of people lost hope then because they had faith in this man. And that's why I always question and think, you make out as though you're doing the right thing for the people, but are you really? Or are you just saying things to get popularity? Are you on a self-serving agenda? We've got to look through. We need everything transparent. We, the people, need to demand this government put everything out on the table. We're the power. Show us everything. We should be seeing every transaction, etc. Okay, inconsistency of laws. We've also got the separation of powers doctrine. Now, the separation of powers doctrine was brought into play because if one section of government had all the power, guess what? There'd be tyranny and bias. It's exactly where we're at. So, chapter 1 is the legislative. So these are the three powers. You've got legislative, executive and judicial. So the legislative, they make the laws and we vote them in. Chapter 2, the executive, they administer the laws. Chapter 3 is the judicature, the judiciary, the courts and judicial decisions. Now the government is trying to override the separation of powers doctrine as well as blatantly disregard the Constitution. The Djokovic case that we saw was a clear example of this. So, the Minister for Immigration has got no right to stand up and say, well, in my opinion, and I'm going to override that judicial decision. So what they're trying to do in effect, this was a clear case of it. They're trying to make out as though the power they have in the legislative and the executive is superior. And a judicial decision doesn't matter. Nuh-uh, don't work like that. He should have been charged with contempt of court and thrown out. We've got a Djokovic case that we're working on as well, just putting all this forward into the High Court. So the judicial power of the Commonwealth shall be vested in a federal Supreme Court. This is chapter 3, the judicature. So I'll just run through. Every one of us can get into the High Court, and I'll tell you how. So chapter 3 of the judicature starts at section 71 of the Constitution. This is the judicial power of power and the courts. The judicial power of the Commonwealth shall be vested in a federal Supreme Court to be called the High Court of Australia, and in other such federal courts as the Parliament creates, and in such other courts, I'm emphasising for a reason, as it invests with federal jurisdiction. So we have got at section 75 of the Constitution is original jurisdiction. Now, that can be related to, I didn't use that much time. Jurisdiction, so you know what's going through jurisdiction 1, 2 and 3. So at point 1, you've got to have jurisdiction over the parties. You've got to have the joinder. Okay, so I'll just write it down. This is under Section 75 of the Constitution. That's where you will find the parties. So any matter that you take into the High Court will be under 75 being the parties. Under Section 76 of the Constitution, that is the jurisdiction for the subject matter. So any one of us can get into the High Court. So that's it, Section 75. So what we've done is, with Section 75, original jurisdiction, we've got that in our later cases. We go in under, for example, Section 75(3), in which the Commonwealth or a person being sued or being sued on behalf of the Commonwealth is a party. Well, guess what? The Commonwealth is going to be one of our defendants. We're going to take them down.
Right.
Because they've done the wrong thing. So this is where we will use Section 75(3). Clive Palmer, he used this Section 75(4) between states or between residents of different states or between a state and a resident of another state. Section 75(5), we've used this on numerous occasions, in which a writ of mandamus or prohibition or an injunction is sought against an officer of the Commonwealth. Under Section 76 is additional original jurisdiction. So that's jurisdiction over the subject matter. We've gone in under 76(1), arising under this Constitution or involving its interpretation, and under 76(2), arising under any laws made by Parliament. The basic principle of law is enshrined and entrenched in the Constitution itself. So, as I said, the court itself must decide whether it has standing in a matter if it's got the authority to make any decision. Are the judicial powers of the Commonwealth going to be engaged? And as I said, a failure in jurisdiction in any of these matters is a failure in jurisdiction. The matter is finished. There is no jurisdiction. It's got to be dismissed. So, this is the other thing to understand as well is Section 77 is the power to define jurisdiction. So under 77(3), which is how when you can invest any state court with federal jurisdiction if you raise a subject matter. So I'll just do. So you've got Section 75, Section 76 of the Constitution. So this one is over the parties, the jurisdiction, and this one here is over the subject matter. Now, you can, if you've got a matter in the Magistrates Court, for example, so if you've been taken by the police into the Magistrates Court, you've been charged with, let's say, incitement or protesting, you can raise a constitutional matter and bring it up under, say, for example, 724 and 128 of the Constitution. Now, what you need to do is, because under Section 77(3) in particular, once you raise a constitutional matter, that court is automatically invested with federal jurisdiction. The thing is, do you want that state court to adjudicate on your matter? No, you do not. Because that's invested with federal jurisdiction. We don't want that. Our matters are of such national significance and urgency, we don't want one magistrate from the lowest court in this land making a decision. Once you've raised a constitutional matter, you're invested in federal jurisdiction. So we can all do this for any matter. You then got to go in and you look under the Judiciary Act, okay? So what we've been doing is, we've been doing Section 40s. So Section 40 is a removal. You raise a constitutional matter, you invest with federal jurisdiction, you must put your Section 40 in prior to a final determination in the court. That involves, so it is under 77(3) empowered by Section 39(2) of the Judiciary Act. That's how you do it. When you do this, you then have to send out what's known as 78B notices, because if you are raising a constitutional matter, taking it to the High Court, the 78B notices are sent out to the Attorneys General across Australia to see if they want to intervene in the matter. Any one of us can do that. So Section 40, you can remove either in part or in whole. So if you're doing it in whole, which is what we've done with a couple, we've actually had our two Section 40s that have been sitting filed for months. Their ears must have been burning. The Magistrates Court sent us emails last week saying that they'd scheduled the hearings for these cases, totally disregarding the law. Section 40s have been sent out. They can't do it. They've got to wait. So, 2 days ago, we got emails from the High Court. Both of our Section 40s have been heard next Thursday, the 10th of March. David in particular is covering quarantine well and truly. So, it's going to be interesting. I keep my fingers crossed, but we're learning as we go. As I said, I've got no legal qualifications, so it's been a learning journey. But we are interpreting and we are getting led by the justices. They are telling us what to do. You've just got to be able to read and comprehend the case law, which is what we're doing, and we're following their tips, shall we say. So, where shall I go now? Okay. Tonight. Oh, beautiful. I don't want to bullpaper with all this. Implied Rule of Law communication, I've done that. There's so much case law in this. Look, the bottom line I want to say to people is, do not be afraid of the High Court. Don't be afraid of the police, don't be afraid of authority or anything else. If we all keep ourselves in the right frequency, we act in peace, in love, in light and lawfully, you've got nothing to be afraid of. Stand your ground and know your rights. So when you do get these ones standing up to you, you can stand back with them. I tell you, the amount of times I've been in the handcuffs and those police were just like, somebody get this woman away from me. I have them leading me off, and they've always got to lead off, one on each arm, and then one will go off to the processing table, and then the one that's left with me, they make, and mind you, I've lectured them all the way, on 15, 20 minutes about the Constitution, don't something and take a step back. So I take a step back so I'm level with them, and I said, no, we've got to stand 1 metre back, so I turn around and face them and go, well, that's fine, we'll just continue like this. I can see their eyes rolling behind their sunglasses. But, yeah, it's crazy. It has been so much fear and intimidation. I know to come out to the processing table and said, so I cried my committed to day officers. And they said, you don't have a mask on. I just looked at them and said, really? I said, well, I don't have to wear a mask. I said, you know it. And they all went, yeah, you're right. They know.
So why do they wear one? To keep their job.
Keep their job. They're not in Victoria now. They've taken them all off. They wear them when they choose. But the bottom line is, anybody can get into the High Court. A writ of summons costs $3,500. That's it. We are forever looking for plaintiffs. But the worst scenario, as with any adventure, shall we call it, you've always got to look at the worst scenarios and prepare yourself. Now, we've got 110% confidence with our cases. So we don't think we're going to lose, but you never know. So we would never ask somebody to be a plaintiff in our cases. Just say the case lost. If you own a house, if you've got money in your account, they can take it like that. So that's why we ask for plaintiffs. We say, where you've got nothing to lose. You've got your assets and everything else set up in private trusts. Pensioners can actually, I'm not far off that myself now, we can go in for nothing. It costs the pensioner nothing to go into the High Court. If someone's unemployed, etc., go into the High Court, you're on Centrelink, for God's sake. What are they going to do? Right, it's going to be $2.50 out of each check. Do you know what I'm saying? So you prepare yourselves in that way. So it only costs, so in the event that you're a pensioner, you go to the High Court, costs you nothing. You present the case, you lose, you've got no money to pay, and they can't take it off you. So it's a win-win. I'm just giving examples. But the only cost, as I said, is $3,500 to submit. That's it. All of this money, that's what frightens people. Oh, it costs hundreds of thousands of dollars. That's because of dodgy lawyers, solicitors and QCs. You're paying for them. In the event that a case was lost, we've already got all the argument for that as well. Will you honour all the government solicitors? All of you. You're already on a wage, are you not? So, where's that coming from? Our taxpayers' dollars. You've already been paid. So why the hell should we pay you anything else? Why should costs be awarded against us in that amount. You've already been paid, thank you very much, and a lot of that's my taxpayers' dollars. So there's all kinds of arguments for that as well. So I guess I'll wind it up there. Don't be afraid to go in the High Court. Stand your ground, learn your stuff. I can't finish something, thanks, President.
What do you think?
There's so much, I mean, I'm going for weeks, there's so much information from us.
So, we actually do have refreshments, etc., so we will be getting up, etc. I think there's some questions. Okay, so Mark, you have a question. Do you want a microphone?
I'll do my best, keep in mind I'm just...
Don't worry.
I'm in kindergarten with this stuff.
I'm highly intimidating.
He's not at all.
No, as you were talking to us and going through the section 71, 75, and so on and so on, all of a sudden you talked about section 40.
Yes.
And I just...
Sorry, I jumped.
I have the problem of having the Constitution sitting here. And section 40 doesn't relate to whatever it was you were talking about. So I got lost.
Oh, okay, sorry. Okay. So section 40 is not section 40 from the Constitution. It is section 40 from the Judiciary Act. Okay, so you need to get the Judiciary Act. And it's section 77(3) of the Constitution, empowered by section 39(2), so it's the numeric 2 in brackets, of the Judiciary Act. Okay, so that's how we go in. Under 41 and 2B, I think under 45, 40 in brackets 5.
Thank you so much for your information and your passion. It's wonderful to see someone so passionate after all
Thank
you've
you.
seen. You know, you haven't lost.
Oh, look, it brings me to tears. I mean, we've all got children, we've all got grandchildren.
Yes, we want a future. But what I wanted to clarify, instead of showing my ignorance, is we've been told that the because they could declare a state of emergency because of the case numbers, that overrides everything. So is that just some crap?
Yeah, that's absolutely correct. There's absolutely nothing in the Constitution that... Okay, I've got case law in here as well, actually. It does not matter what state of emergency arises. Nothing suspends the Constitution. Nothing.
Yes.
Exactly. And everything I've said to you, they can't. They've done it. They have a blatant and utter disdain for the law of this land. They're not even adhering to the Biosecurity Act. So that's the other thing, and that's where Section 109 of the Constitution comes in.
So, Jacquie, there's also one thing I mentioned to you earlier, the International Covenant of Civil and Political Rights.
Yeah.
Even in a state of emergency, you have non-derogable rights, and that's part of what Jacquie's talking about. The state of emergency doesn't remove any of the rights that Jacquie has told you you have.
There's so many things. We've got what Stephen said. We've got the Charter of Human Rights and Responsibilities. We've got the Articles. We've got the Covenants. We've got everything to protect us. They are not adhering to anything. Now, the Biosecurity Act is a federal act regarding quarantine. Biosecurity Act 2015. That overrides any state public health act. The Biosecurity Act clearly states that you need to be handed a control order by a Commonwealth officer, a biosecurity officer, and that must list what disease you've got. And they can, so they're not even adhering to that. And as I said, quarantine's only applicable if you are diseased, if you are ill, if you are labouring under an infectious disease.
Jacquie, does that apply to a stay-at-home order issued to a state?
That's
or
all
to a region? The fact that it has to be issued to you individually?
Yes, yeah, in fact, it's even in the Health Act. They've got that written as well. You see, they're not adhering to anything. They're not adhering to the Constitution, they're not adhering to the federal acts, they're not adhering to the state acts. It's insanity. They are just doing what they want, and they have relied on the fear that they have just continually pumped out. I mean, they've only come recently and admitted that all of those COVID cases, it was a high number. It was like 87%, or was it higher? 90% of those cases, actually, they all had underlying underlying health issues and really died from that. Like, the whole thing is a joke. They are putting it in our faces. You've then got the thing they're doing in Victoria in the news. Well, the cases are now 79% cases of COVID in the hospitals are double vaccinated. 17% are vaccinated. 2% are unvaccinated. But they're putting it up there. It's like, what? So, you're forcing me to have a vaccine that doesn't stop me getting it. It doesn't stop me spreading it. And by the looks of the data, I'm more likely to end up in hospital. Are you kidding? This is the thing. It has only got it's only got an approval to be used in a state of emergency. That's why they've done this. And the other thing I say to people, subscribe to Parliament. Go into that website, subscribe to Parliament. It doesn't cost you anything. They will send you all the bills they are proposing to turn into law. And one of them is, Scott Morrison is trying to make it a law that for national security we can't disclose to the Australian people what happened in the National Cabinet. They're also doing an amendment to the Health Acts across Australia, which has just wiped out, guess what? Nah, no consent required from the people anymore. We just do what we want. They're removing everything. Everybody here, if you own property, if you own anything, get it into a private trust. This is an economic collapse. It is a pharmaceutical takeover. There's stuff on the dark web. I've got a girlfriend who searches that for High Court case law. 2008 Brigalow Agreement. They've already put all land rights and all titles in their name. We already own nothing. They have shredded all the paper titles, historical titles. They've been shredding them now for over 18 months. Queensland's done. New South Wales done, they've been doing it in Victoria, it's going across Australia. If you've got your title, hang on to it, you're still not safe. Get your assets into private trust. If you've got any currency, gold and silver are the only ones. Now this is my opinion, okay, I'm going into my opinion. Gold and silver, don't use Bitcoin. Don't use, what's the other one? Bitcoin.
Bitcoin.
Crypto. No, it's all digital, and this is what they're trying to do. They're trying to get us into a digital society. They're trying to do what is happening in China. So everything you do, they monitor. Where you are, what you purchase. Bad citizen. She spoke badly about the government today. Might take her house off her.
Yeah, well, no,
that's what we're going to do.
Can I just ask a question in relation to whether they're using approved, we know about vaccines, right? They're saying approved vaccines. Have you, not to put you on the spot, but have you had a look at the difference between approved and provisionally approved?
Oh, sorry. So you're correct. They've only been provisionally approved.
What I'm saying is they say for an approved vaccine.
Yeah.
They don't actually say for a provisionally approved. So
What does it say with
TGA?
TGA?
I wonder if that's been looked at, because that's another, assumption.
Yeah. Look, the thing is, that's why as we prepare these cases, we go in strictly under the rule of law, the Constitution, using High Court case law precedents, because it doesn't matter what subject matter you go in with. You can go in with the data from the most learned intellect, in the world regarding whatever subject. I'll bring in their dodgy experts, sorry, experts don't agree with that, and I'll throw it out. So that's why we thought the only way to do this is to go in and fight it in this way. We've got a lot of work ahead of us. The taxation department is not constitutional. Tax is voluntary. There is goods and services. The Constitution only allows for one tax. What's goods and services? It's two. They tax us over and over and over. They are a corporation. We all know they're a corporation. They've got an APN number. They are acting as a corporation. Do you know that they all own water rights? And under Section 100 of the Constitution, what's her name? Helen Dalton. She's someone in Parliament, isn't she? Helen?
Jane.
Who's it?
Jane.
Is it Jane Dalton? One of the parliamentarians stood up and she said, right, I'm going to let the people know here and now. I've got water rights, just like all of you do. Who else is going to admit it? Look, the other things they're going to come up with is climate change. The climate change bullshit. The Earth is a living, this is my opinion now, the Earth is a living entity. It has been going through climate change since the day it was born. Oceans rise, oceans fall. New lands rise up. Sections of continents and lands go underwater. It is continually changing. There were oceans through Central Australia at one stage. The evidence is under our nose. There are fossilised seashells in Central Australia, in the cliffs. Egypt was tropical. It's in front of our noses. Wind erosion creates sharp edges. Water erosion creates curves. Look at the body of the Sphinx. They hide everything. History is a lie. They have been lying to us for hundreds of years. They tell us the story they want us to know. Even World War II, one of my Japanese friends who we were over in the States there for a couple of years, you know, like a big community over there. And he was saying that in Japan, they were starving. That country can't sustain themselves. They were starving. They cut all access to food off. They retaliated for that reason because they were shut down. But do you hear any of that? Well, and look what they did. They bombed them. For God's sake, Hiroshima and... Look, the atrocities, they tell us what they want us to believe, to put them in a good light. Everything is a lie. We're in the dark ages now. You've got to look at the ancient civilizations. Look at the technology they had. We still cannot create some of the amazing structures or architecture that they did back then to the absolute exactness, even with all that technical stuff. We've got to go back into ourselves. We've got to ground. We've got to get back to nature to a certain extent. And one of the other ways to win this, other than being in the High Court, is to get communities together. We need to work together. Everybody needs to stock up on seed. Sorry, I'm a prepper. This is my opinion again. If shit really hits the fan, because it could, that's the worst scenario. Have seeds. We must be able to grow crops. I'm a horticulturist. I've set up permaculture systems, etc. If you don't have much area, you can do multi-grafts with things, etc. You can espalier things for small areas. But you must collect seeds. It's our food source. Heat's okay, wood fires, we all know how to make fire, but get your rocks, get your flint and everything else so you can learn how to do it. Get the old books and learn how to survive without the government. We do not need to be reliant on them. This country, back in the 50s, our dollar was the highest in the world. We were the lucky country, and every country envied us. We had the best in everything. We had the best production and manufacture, agriculture, everything, amazing inventions and scientists. We were renowned. What happened? Look now. All production and manufacture has left this country. Foreign entities are coming in and buying everything. Our tollways, another one in Victoria, is owned by a foreign entity. That toll was meant to have stopped 25 years ago. So now we're putting money into another pocket. I had a friend that went to court about that, had 40 grand in tolls racked up. He just went into court and said, so, what, the police are now collecting money for a foreign entity? And he had all the evidence there, and they just threw it out and said, forget about the fines, don't tell anyone. Like, there's so much stuff that is going on. We are being screwed over. This corporation does not care for the people. All they care about is controlling us. Wages and the cost of living have always meant to go up together. Has that occurred? No. No. Wages stopped going up a long time ago, and the cost of living has skyrocketed. Hence, we now have two parents heading off to work, struggling. What's that doing? That's leaving our children. Our children to be looked after by others. It's breaking up the family unit. We have got to get back to what is within us, what we know is right. We've got to ground ourselves, earth roots, learn the land, family first, and stand up and unite with each other. That's what we've got to do. I read.
Because that's important, that's a way that we can be grounded and communicate our aims.
And after this one, we're going to have some food and intermingle. But I want to say one thing before she gets home.
Well, the protesting comes under the implied freedom of political communication of 724 and 128. And the reason it is an implied freedom is because it doesn't specifically state it. But those sections are all about we, the electors. So the reason why it's important to protest, not that it's done anything. I mean, we had I think it was 1 million in the streets of Melbourne in some of those big protests that we held. The reason the protest is so important is because a government is not truly representative of the people if it can't hear the voices of the people. And we are not being heard. Everything is around the wrong way. The media is meant to, journalism used to entail somebody going in and questioning two parties with opposing ideals, for example, and getting the opinions of both. So it used to be like a debate. Now, does that occur anymore? No. A script is read. I mean, I'm sure all of us have seen these things where you switch onto a TV channel, they're all reading word for word, and then they put up 10, reading word for word. Then 100, and the whole screen's covered with them all rehearsing or saying the narrative. They're given scripts. They're lying to us. I mean, every time you put something about that goes against Facebook agenda, it comes up with, if you want to know more about COVID vaccines. You open that up, it is lies. They have not been safely tested. I go on and on, but protesting is important so that the government can see that we, the electors, are not happy. And this is the main thing I say when I'm marching the streets and we're going through all the police. I let the police know that this is our implied freedom of political communication. I quote it and say, we, the electors, must have our voices heard. And we have been left with no other choice than to walk the streets. Because we're not being heard on the TV, we're not being heard through the media. Everything is being suppressed. It's total control, so that's why it's important to protest. But that's why I looked at the other strategy as well. It's important that everybody start understanding how we can take things into the High Court. Pensioners can go in for nothing, and if you lose, you've got nothing to lose. If you're on a pension, but don't own anything, so yeah, just in case. But thank you. Thanks, everyone.
First of all, thank you so much, Jacquie. That was just amazing. It's very, very informative. The one thing that she did mention was about Arby. Now, I've contributed to Arby in their court cases, and they will make $150,000
Per case.
Okay? Now, the thing that we like to do for Jacquie and her team of people is perhaps support her like we've supported Arby. So we're going to put her webpage on there and see if we can donate. Because I think even Chad said to me, I've got to donate more now than I've ever done before. I've done the same thing to many causes. And here's somebody who's actually fighting for us at the right level and being our voice. So that if you're wanting to do that, we'll probably put it on Eurobadella United, where we can help her people, because she's getting to a point where she can't keep afford doing this, and she's not getting the advertising that Arby is, and to think that he's doing the wrong thing by us pisses me off. So if we can all think about maybe helping Jacquie Dundee, and maybe that's the reason she's meant to meet us, so that we can get it out to all the people that we know and try and help her. So I think that's something that we would like to do with our group.
Any support would be welcome. I mean, out of all of our donations, there's 4 of us. We're in trouble, all of us. Well, I nearly lost my house. So out of 15 months worth of work, 10,000 of the donations went towards me just so I could keep my house and pay my bills. Like, we really are struggling.
So let's try and put this together. Let's spread it. Yep.
You have to watch transactions. Every electronic thing put on the net or phone line, everything's all recorded now.
Sure.
So we don't get another scenario of the Canadian truckers.
Yeah, I know.
We're going to have to send checks.
We've got to
Send you an account would be better.
Yeah, we might be able to do that.
Would be better.
So finding a way in which we can do that. I mean, Liz and I will probably have that information.
What about PayPal?
Yeah. So look, we'll find a way in which we can get the money. Maybe it's not going to be the point of contact, and then we can get it into Jackie's thing. So it's just finding a way that we can do it here. Maybe we can give it to Lillian, who can also handle some of this with Shaz, and they can work something out with Jackie's account, so that we actually do it either through cash.
We'd set something up because it's going to be transparent.
Yeah, so we'll find a way with Shaz and Jackie working something out between the two. That works. So let's just think about what we can do. I think now we can all just get up, enjoy this with some lovely sandwiches, we've got vegetarian things, some coffee, and she just wants to say one more thing.
So I forgot to let people know that this one is really important. What we're also doing, I think most of you have heard of Dr. Hobart. We're working with Dr. Hobart. What's been going on with ARPA and the AMA? They've been walking into the doctors' clinics, and if they're not compliant, they're deregistering them, saying that they are going to cause harm to the public. Now, those orders by law are only interim, they're only temporary. This is another thing that's totally upside down. If you commit a crime, okay, so if the police charge you with something or make an allegation, you go to magistrate's court, the police are the applicants, you're the defendant defending yourself. What's going on with the doctors? The lawyers are taking them in down the wrong path. So the doctors, lawyers, are getting them to go into the tribunals as the applicants. Now, they lose. They're all losing. But guess what? When you're taken as the applicant, you've got no appellate rights. So we stepped in with Dr. Mark letter, ARPA and the AMA, and we said, doctor is a title that Dr. Mark Hobart has earned, as has every other doctor. And they all have the right to use the name. That is out of your jurisdiction. We did a whole lot of stuff, put them in line. We got an email back last week. Dr. Mark can actually use doctor, and we're dropping all the criminal charges. And guess what? We're sending them to the Supreme Court, and we're moving it up from there. We're working with 2 doctors. People have lost your job. We are also working, we've got so many cases on the go, but these are going to be landmark for people. So there's a woman who lost her job. She goes to the Fair Work Commission, and they say, no, this is going to go to the Industrial Relations Commission. So if you raise a constitutional matter, okay, in the commission, in your application, this is the important thing to know, you raise a constitutional matter. Tribunals and commissions are not courts. They have no jurisdiction. So you can take it straight into the High Court. But how many people get it out there to anybody whom you know who has actually raised a constitutional matter in their defence in either a commission or a tribunal case? Because the decision in that case is null and void. It's got no standing in law whatsoever because it is outside their jurisdiction. All you've got to do is mention a section of the Constitution, your constitutional protected rights. And I'm sure there are hundreds of thousands of people that have lost in these courts and tribunals. All of that is I think that's it. If they've raised a constitutional matter.
I have one question, Jackie. Is there an easy way, if you want to fly overseas, to fly without the jabs? Because like what you just said before.
So you're talking overseas. As I said, I'm in kindergarten with this, and it's a constitution and high court case law.
No, just to get out of Australia, because the Australian constitution, like you mentioned, gives you the...
My understanding is there are a lot of countries that are not requiring that same passports.
No. It's getting out of Australia.
Yeah.
Freedom Alliance Airlines, I've interviewed them in the last 2 weeks, and they're moving people from country to country. They're using dead legs on international flights. They're hiring private planes. They're also using private airports.
Yeah, I know several people who are just flying out. They've left the country. No vaccines, no Thank you very much, everyone.